welcome back to yet another fabulous episode of our talk show with experts. Manatho and Mana expert Rahul Reddy Garu. Rahul Garu, thank you so much for being on the show today, Andy.
Thanks for inviting me, Garu.
Absolutely. To the folks who are watching, please call us. Our number is 1-833-882-8872. The number again is 1-833-882-8872. Watch us on Yup TV, Facebook, YouTube, Sling TV, World BB TV, and Dish Network. All right. I know we were set up to discuss a different topic, but Rahul Garu, it's come to our notice that this is something that's sort of bursting at the seams now because it's been a very, very new release, the border bill. So it says that the border bill offers extra 18,000 green cards for employment-based and EAD for the H-4 children to avoid age out. Rahul Garu, tell us about this border bill. What is it doing? How come we've never heard of it? And is this really happening? And how does this help us?
Good question. Why did we never hear about it? Because it was a border bill, nothing to do with employment-based immigration. So It's a 370-page bill. For example, ELIGIBILITY and all those things, they are like 3-page bills. This is 370-page bill.
Wow.
And the Senate, bipartisan Senate, including the Democrats, Republicans, and an independent, well, Arizona Senator claims himself to be independent, even though elected from Democratic Party, Sinema. So they released this bill as a compromise between the Democrat and Republicans. Now, there are bills that are related to restricting people at the border who are coming illegally into the United States, making it harder for the fraudulent people to file the political asylum, because right now people can file a political asylum and get some benefits, temporary benefits at least, and it's going to take a while to get to the court, and they're restricting those things for only the absolute needed people, though. So it has provisions with regards to funding Ukraine, and so it's more bipartisan bill. So it's 300, let me check it, 370 pages, though. Out of that, the provisions related to the employment-based is less than 2 pages. So somewhere they inserted this. We were not aware of it. We were not. These are the kind of things that happen, though. Is that one big bill is about to be passed? They use some immigration provisions. Sometimes it may be restrictions. Sometimes it may be advantage. Now, there are a lot of immigration restrictions, though. But as far as the employment-based is concerned, we are good. There is no restriction, none whatsoever at all. In fact, we're going to have, if this bill is passed, which seems to be a bipartisan, seems to fail in Senate. Remember that for Eagle Act and all those things, it was always the Senate that is a hurdle. This time, it looks like it will pass through the Senate, but we don't know yet if the House will be convinced or not. So that we have to look into. Now, remember, to pass this bill in the Senate, we need 60 votes. Not the Democrats have only 51 votes, not 60 votes, though. So it seems that it's going to be, because it's a bipartisan bill, it seems that it's going to pass through the Senate. House is in the Republican side. We need to see how it's going to sail. But we should support this bill. Now, don't call me and saying the other immigration agents, supporting agencies may support, but we at TVASIA should support this bill. The reason is that it's giving extra 18,000 green cards for the employment-based, unfortunately only for next 5 years. That's still, it's almost like...
how did they even manage to get that number in?
I don't know what made them think, maybe some good person in that who is drafting the bill added these things and they won't even notice. They probably
just randomly added 18,000, is it?
18,000, yes. They said they put a restriction. It's only for the next 5 years, though.
Okay.
Now, these kind of provisions happen, especially, for example, H-1B quota was 65,000, remember? And it is still 65. But back in old days, remember 2001, 2002? Back in those days, it was up to, wow, I think so, 190,000 or somewhere around that part. But it's only increased for temporary period of time. Not for the entire time. So they're saying extra 18,000 employment-based green cards only for the next 5 years. Now, there is also provision for the H-4. Right now, only the spouse of the H-1B who has an I-140 approval gets the employment authorization. There is no provision for the children to get it. So if the children who are on H4 wants to do internships, technically they can't do internships, and thus by they will forego the things. So what they're telling in this bill is that even children whose parents' I-140 has been approved will be eligible for the H-4 EAD.
Okay, that's great.
Okay. Now, I have yet to see whether, it's a 370-page bill, so don't cross-examine me, guys. I'm giving you, there may be provisions where we don't know whether I-140 is required or not. I'm still reading it's 370 pages bill. It's released 1 hour ago. I'm not that fast reader though.
Sir, there was a brief mention of avoiding the age out part of it. Can you just...
Right. So we know that if the priority date doesn't become current, the children will be aged out. They'll be kicked out and they have to swim on their own when the parents' priority date becomes current, right? We know that. So this provision says that in this one, if the child has spent 8 years on H4, only Indians can stay 8 years on H4. You know why? Because after 6 years, they lose the H4 status, right? They have to get an I-140 approval. Only Indians are backlogged in it. So this is particularly for Indian. It's going to benefit the backlogged countries, which most probably India falls 95% of it. So especially for Indian kids who have spent 8 years or more on H4 will not age out.
Got it.
So no matter whether they become 30, when the parents' priority date becomes current, they can still get the green card under this provision. So the thing is that the child has to spend 8 years on H4. So the child must have come into this country before, I would say maybe 13, somewhere around 13 or even before the age of 13, the child has to come. Because in 8 years, they become 21, right? So they must have come before 13 years and must have spent at least 8 years on H4. They would be eligible for they will never age out. In other words, they will be allowed to include. Now, I still need to look into the provision. Does it mean that they can remain on H4 even after they become 21? I don't know anything about that at this point of time. But we will be able to find out. Watch the TVASIA news. We will update those things next week.
Perfect. And sir, how is this 18,000 going to be distributed? Like, do you have any idea about what they're planning with it? Or?
Yeah. Well, we already have, Srinivas already comment on that. This 18,000, would we get only 7% of it? Did we get the whole? Definitely, we will get 7% of it. That's 18%, 7% is how much? 10,000 is 700, somewhere less than 1,400. Yeah, you're right, Srinivas. But however, though, Srinivas, here is the thing, though, that when if the rest of the world doesn't take it, hopefully so they don't take it, then we'll get it.
Okay.
If the rest of the world don't take it, then we will get it. Now, it doesn't say it's for backlogged country based on my reading. Let me check with Emily. She's been updating me. Okay.
And this covers all EB1, 2, and 3, correct, sir?
Yes, this 18,000 is for all, EB1, EB2, and EB3. Yes, this guy already calculated, Srinivas Lugaru already calculated, saying it's 360 extra green cards. Well, Srinivas, I will take it. Whether it's 360 or 100, any extra things, I take it. So I definitely will support it because we have nothing to lose in this one.
Lose in this, okay, got it.
Yeah.
Got it, sir. Anything else that you can, shine some light upon for, as
right. No, nothing else because it just came. I just saw this one like 10 minutes before the show, and then I was able to skim this 370 pages bill, and me and Emily were skimming through that and got some of the provisions in there.
Thank God for lawyers. We get an update so soon on this bill.
Yeah.
Rahul, thank you so much for keeping us updated on this, and I'm sure in the coming weeks we'll hear a lot more about this and, how things are looking for everybody across the globe, I guess, employment-based wise. So, okay. Anything else to add to with regard to this topic?
No, we can go to Q&A.
Okay, cool. And Rahul Garu, just a quick minute. Let's just touch upon this other topic we were going to discuss about working for multiple employers and the pros and cons on OPT STEM extension, H-4 EAD, H-1B, and AOS EAD. So Can we like quickly do a roundup on that, and then we'll take our comments?
Sure. Definitely on OPT, you can be employed with two companies. Absolutely not a problem. You have to inform the DSO about the two employers. The employment must be in the relevant field. There is no provision that says you have to be employed only with one employer. In the STEM extension also, you're allowed to do multiple employment. Both the companies must meet the requirement that it must be E-verified company. Both the company has to submit the 983 form to the DSOs to be eligible for you to be employed with both the companies. It's a misconception that you can only work for one company. No, you can work for multiple companies. Also on H-1B, I have done for one guy, 6 companies he's working for. He's a dentist. Here appears, there appears, there appears. I put a provision normally. He comes and says, I can work for 2 hours. Sometimes I have to work for 40 hours. So we put a limitation, 2 to 40 hours in each of those things. So in that way that he can at a minimum work 2 hours, at a maximum he can work for 40 hours. Yeah. So yes.
That will come under the concurrent H-1B, sir?
Concurrent H-1B. That's right. Okay. Concurrent H-1B. Now, if one employer is sending them to multiple employments though. So let's say Nitya Garu is an employee of ABC company. If they're telling you to work for AT&T and if they're telling you to work for Pepsi at the same time, you don't need to file any amendment. They're allowed to do it under the current provision. As long as they're meeting the LCA requirements where physical location is the same, you're not, let's say most of these people are working from home, then you can meet the requirement and you're fine with it. We don't need to file a concurrent employment. We don't need to file anything. We don't need to file anything.
Got it. Okay.
Now, also H-4 EADs, there is no limitation. They can work for multiple employers. Adjustment of status EADs, they can work for multiple employers. And if they are the primary applicant, though, the main job has to be in the similar profession. The second job could be anything else. Doesn't have to be there. So if the main job, let's say, for example, the main job is an IT profession, and the secondary job, let's say, for example, they want to work as a gas station pumping, petrol pump guy, to pump the petrol, they can do that. Or a Uber driver.
Sir, so this would also include setting up and running your own business as well, right?
Absolutely, you can.
Okay, so for the guys who are watching, that's an added incentive to get off your H-1Bs and, get onto your adjustment of status EADs, if you're thinking of...
They all love to, but we need to get these bills passed or anything like that. They all love to. Now, if they're given an opportunity to go to the adjustment of status EAD, I bet 99.99% will go through, and that 0.01% is a crackhead.
Yeah. All right. Thank you so much, sir. Let's take our first caller for the day then. Okay. Caller with number ending in 7383. 7383, we're ready for you now. Hello? Caller with number ending in 7383. We're ready for you. Hello? All right, let's try another caller. We'll come back to this one. Okay, caller with number ending in 4795. 4795, we're ready for you now. Hello?
Hi, Nitya Garu. Are you able to hear me?
Hi, ma'am. Yes, I can hear you. Thank you for calling. Please go ahead with your question, ma'am.
Yeah, thanks, Nitya Garu and Rahul Garu for taking up my call. So my question is that we have AOS under both EB2 and EB3, but my son is protected with CSPA under EB2. As per the CSPA rules and all, we got I-140 and the date is current in last year, 2022. So he's protected under EB2, but when we downgraded, we have applied for EAD and AP only under EB3 in 2020, not in 2022. So now we got EAD, AP under EB3 and we have renewed it too, and we got 5 years AP EAD combo. So my question is, can my son now move to EB3 EAD? He want to do some internships, so...
Yeah, he definitely can. You can even file under EB2 EAD also if you haven't filed it. What I would like you to do is, I don't want the USCIS to accidentally approve your case under EB3 and deny the 485 for your son. I want whichever company that you're working right now, file a 485J supplement and request the USCIS for the EB3 application please adjudicate this application under EB2, not under EB3. I also want you, the main applicant, or your husband, whoever is the main applicant, request the USCIS, please consider this only under EB2. There is a danger that my son may have some issues under CSPA. So please do not consider my application under EB2. And if you still act and go ahead, I will consider going to the federal court. I want you to request them, if not threaten them. The reason is that when the date becomes current, they get the file, they want this number to be approved, which, there are nice officers. I'm not going to blame them, but I don't want your case to be approved under EB3. You got it?
Okay. So, but for under EB2, we didn't apply for EAD and EAP.
That's
is
fine,
it okay,
ma'am.
sir? So,
It's what
okay.
I'm telling you is that even if he uses the EB3 EAD, request the EB3 to be converted to EB2. That's all I want you to do. Okay? Okay then. We'll go to the next question.
Okay, sir. Thank you.
Okay, ma'am.
Please
Thank
listen
you so
to
much.
this one after you exit. Listen to what I said so you will understand it. Next person, please.
Yeah, I got it, sir. Thank you so much. Thank you.
Thank you so much for calling. Let's take our next caller. Okay, caller with number ending in 7383. 7383, we're ready for you now. Hello? Caller with number ending in 7383. We ready for you? Hello? All right, let's try another caller, Andy, in the meantime. Okay, caller with number ending in 9003. Hello?
Hello. Hi, do you hear me?
Yes, sir. We can hear you, sir. Thank you for calling. Go ahead, sir, with your question.
Oh, hi. Hi, thanks, Rahul. Hi, I have one question. So my AOS application was filed under EB2, like that category in India in October 2020. This is the same downgraded case.
Mm-hmm.
And my priority date is
Wait. You filed in EB2 and it's a downgraded case. Those two sentences are not matching.
Yeah, it was a downgraded case. So I think I filed on EB3.
Okay, so now
it
you
was a
filed in
downgraded
EB3.
case on EB3.
So it's EB3. So you filed under EB3. Okay, keep going.
Yeah, so I filed on EB3 and on October 2020. My priority date is 2013. Then I received my EAD AP. All those things happened in 2021. And unfortunately, I didn't get my green card. I was not lucky enough. And then on January last year, January 2023, my EB1A petition got approved.
Okay.
And in the approval notice in the petition, they didn't reflect my original priority date, which is 2013. Rather, it is showing a priority date as 2022. That is the date when we filed the. This is the time. This is actually the receipt date of the petition. So basically, in the approval notice, they didn't reflect my.
I got it. What is your question?
Yeah. So my question is: so in the following month, my employer they went with interfiling, like they submitted Form 485 Supplement J. And also at the same time, we raised multiple service inquiries to USCIS to correct my priority date in the approval notice.
Practically, what you're telling is that you got an EB1A approval, you requested the USCIS to adjudicate your approval, and they are not looking at it. The best solution for you is to sue them in the federal court, though, because when you sue them in the federal court, though, it gets their attention, though. They will once you sue them in the federal court, they have 60 days to respond. These kind of things where they're very clearly approvable, they should have been given the previous priority date of 2013. They should have approved. Normally, not a guarantee though. Normally, what the USCIS does is, within 60 days, they will just approve the green card and then they will call you up, they will call your lawyer up, hey, your client's case got approved, why don't you withdraw it? Sometimes they will ask for extra days. Hey, Rahul, can I have extra 20 days? I'm working on your client's file to respond to the court. So that's fine, go ahead, take extra 20 days. In this 20 days, They just adjudicate the case and then they'll tell Rahul, why don't you withdraw your case? So go to the federal court. You can try all the things. Sometimes it may work out, most of the time it doesn't. This one, most of the time it works. Very rarely it doesn't work. Okay?
Okay. So in continuation to that, so what happened is like in November last year, my AOS case moved to Los Angeles field office. I received a medical RFE, and in the few weeks I responded to the medical RFE. USCIS received my medical RFE, and in another 2 weeks, around 20th of December last year, my supplement J, 45 supplement J got approved.
So we can keep on going on for the whole day. What is that you want to tell? Don't tell everything.
So what I'm telling. Okay. So finally, what is happening is that my case has been upgraded to EB1. However, my case has been, the status is showing that it is in the case remains pending because my visa date is retrogressed. I had a talk with the tier 2 officer last week, and he said that first
you have to stop right now. Don't tell me everything. Okay, right now what you did. It's going to take an hour. Okay, It's not what is that you want? You want your case to be approved in the green card, and then I told you the solution. Tell me why you don't want that.
No, I want that. I'm thinking of doing that.
We'll go to the next person, Nitya Garu. Do that, please. Okay. That's the easiest and better solution. Don't tell me all the things you filed 485J, EB1, green card, priority date is correct. They are not adjudicating it, period. Go to the court. You filed in 2020. Go to the federal court. Next person, please.
All right. Thank you, sir. Thank you so much for calling. All the very best. Okay, let's take our next call.
Sorry to cut him off, Nitya Garu, but the best solution for him is that not that he filed 485J. Everything he's done good, but they are not paying attention to him. When you don't pay attention, sue them in the court. That's easier. That's cheaper because with all the steps that he's doing, contacting, speaking with them, he can work in an Uber and make that money to pay the lawyer.
Right. So, sir, is there someone in your firm that can help with something?
Not me. There's a guy by name Stephen Brown in our office who does that.
Stephen Brown. Okay.
Yeah.
So, sir, if you're watching this, the previous caller, if you're still watching this, contact Mr. Stephen Brown at the RN Law Group, and they'll be able to help you out. Okay. Let's take our next caller. Okay, caller with number ends 7383. 7383, we're ready for you now. Hello? Hello?
Hello.
Hello, sir.
Are you hearing me?
Yes, sir. We can hear you now. Thank you for calling, sir. Go ahead, sir.
Yeah, thank you. Yeah, I have, thank you, Rahul Garu and Nitya Garu, for your support. I have one question. My priority date is November 2013. I have a GCEAD. It's valid until 2028, and my I-485 is pending. And since my 485 pending, my dependents is when my dependents entered to the US in the H-4 status, should they immediately file their I-485 upon arriving in the US, even if my PD is not current?
They can't. They can't. And you have to maintain the H-1B status, otherwise they're going to go out of status. Since the priority date is not current, go ahead.
Yeah, right now I'm using the H-1B only, not GCEAD.
That's nice. That's nice. So once they come in, they cannot file the 485. If the priority date is current, though, of course I want you to file the 485. But if the priority date is not current, the way you are explaining it to me, there is no way they can file the 485. The 485 will be rejected if you file it. So wait until the priority date becomes current and maintain the H-1B until the priority date is current. Okay? You can apply your wife's H-4 EAD though. Okay? And if this new bill passes through, your children also can apply for EAD. Okay? That's H-4 EAD,
which bill,
not under adjustment of status. The border bill we are speaking about. Okay?
Oh, okay.
But right now, when your wife comes in, she comes in H-4, she can apply for the H-4 EAD because you're maintaining the H-1B, your I-140 is approved, okay? They cannot file the 485. Right. Keep watching the visa bulletin just like the way you're doing it. Once the priority date becomes current, contact your lawyer. I want to file the 485 for my wife, okay? Wish you best of luck.
Okay, thank you.
Thank you,
Yeah,
sir.
thank you.
So much for calling, Andy. Okay. All right, let's take our next caller.
Bye.
Bye. Okay. Caller with number ending in 7585. 7585, we're ready for you now. Hello?
Yeah, hello, ma'am. Can you hear me?
Yes, sir. We can hear you, sir. Thank you for calling.
Hello,
Go
ma'am.
ahead,
Can you
sir.
hear me?
Your question. Yeah.
Yeah. Hello, Rahul, sir. This is a continuation, like I asked a question before, but so this is my scenario is like I have multiple employees who filed for 485 back in March. My previous employer did it, and in
Multiple employers
category
filed 485?
Correct. So in March of 2023, my previous employer filed 485 application supporting via Supplement J, and my current employer also filed 485 in June 2023 in EB3 category. The first one was in EB2. And both of them are both of them. I got an interview call for 485, and I have a question regarding how to respond. I mean, so one of the documentation that I need to carry, right, which is I-140 petition and copy of labor certification. My current employer and previous employer, I have a I-140 approval notice, but I don't have the petition.
The petition is not required. You don't absolutely need to carry the petition though. If you have an I-140 approval, that's good enough though. And they may force you to withdraw one of the 485. Is your prior date current right now? Under either EB3 or EB2?
Yes. Yes.
Yeah. So when you go there, they may force you to withdraw one of the 485 application. Okay. You may want, which is your current employer that you're working, is the prior date current with the current employer?
Yes.
With the current employer. So you can withdraw the other employer though. You can withdraw the other employer though. They may request you, force you. Since they see 485 application, they don't know what to do with it and they get confused with those things. Their system doesn't allow to do the things. So you may want to actually withdraw. They may force you to withdraw one of it. And you need to take the employment support letter with the current company. And they may ask you the question, why did you file the 485 with a different company? You can say, because I want to get the green card as fast as possible. Would you have joined, then why did you file with both the companies? If I get the green card with that company, I would go jump and go and get the go and join that company. Whichever gets the green card, I will go. I want to get rid of Rahul Reddy and TVASIA in my life. I don't like them. So nothing wrong with it.
Yeah. So,
okay.
If they ask me, like, why didn't you withdraw that other application until now? So
because I want to get the green card.
Trying to understand, like,
I want to, you can say that. Which one moves faster? And then if they ask you, would you have gone and joined the company? Absolutely. Well, you're making $200,000 here. There, it's only $80,000. Why would you go join the $80,000? Because I don't want to see Rahul Reddy's face ever in my life. Or an immigration lawyer's life in my life. Nothing wrong with it.
Yes, sir. So one additional question. Back in 2010, like, I did a employment transfer from a previous employer to other employer. So at that time, I got an extension. My change of status was when the H-1B was approved, but the extension stay was not approved. So I moved out of the country, came back in. But one of the questions that was asked, right, have you been ever out of status? I answered no, because based on my current employers.
So how long were you after the status was denied? You left the country.
Immediately, like within a week.
I don't think so. That's a problem. I don't think so. That's a problem. Is it an extension or is it a transfer from company A to company B?
Transfer.
If it's transfer, let's say you're moving from company A to company B. Did company A's H-1B I-90 797 I-90 the 797 expired before you got the denial with company B? Change of employer?
No.
Okay. No. Why was the change of employer denied?
I think what happened is, like, I got laid off, and then in the meantime I applied for the infamous Tribal University, and then that got denied subsequently. In the meantime, I got this new employer. I filed.
I got the point. And so there was a gap of pay period from the company A to company B. that is considered to be out of status though. However, there is a USCIS memo that states very clearly that they cannot count any out of status they can only count the out of status from your last entry into United States to the time you file the 485 application. They cannot look into the previous violations, status violations. Now, not unlawful presence, but status violations. Since your previous company is I-94 is still valid though, technically at the most it's out of status. Since the memo says that they should not look into it, based on that memo you answered it, I'm not expecting any problem for you, sir.
So since I answered no, but during the interview they say why are you been out of status?
It should not create a problem because they should not consider it. You only meant the status violations from the time of your last entry into United States, not the previous violations though. I'm not expecting any problem, but if you want, you can take a lawyer with you or have a lawyer interview you and how to answer those questions privately. But I'm not expecting a problem. If I were you, I might not even consult the lawyer. Next person, please.
Okay.
You're in good shape, sir.
Thank you, sir. Thank you for calling, Andy. Okay.
Thank you.
Let's take our next caller. Too many. All right, caller with number ending in 1795. 1795, we're ready for you now. Hello?
Yeah, hi. Thank you for taking my call.
Hi,
I have two questions actually. Yeah.
Go ahead.
So the first question is, I think I tried to call you guys before as well. My PERM was applied in November 2022. So my question is, can I have a different employer, a potential prospective employer also applying a PERM?
Right now, absolutely.
Like, can I have multiple?
So you can have multiple employers file the PERM at the same time. It won't cause you any problem, none whatsoever at all. Okay?
And can I still stick to this employer? And if everything goes fine, can I switch? Is that an option?
Yes, ma'am. That's an option. You can do that.
And the next question that I had was, so since I applied in November 2022, I physically changed my residence in 2023 April.
Is it a consulting company or a non-consulting company?
It is a non-consulting one.
And the address change, how many miles is the difference between the previous address and the current address?
So I looked up in the MSA. Looks, it's within the city, so it's not a big
I didn't
change.
ask you a question, ma'am. Just why don't you give me the mileage to me?
Okay, it's about the difference between the first location and second location. Is that what you're asking?
Yes, ma'am.
Or from my work location?
From your house, one house to another house, what's the distance?
It's about 18 miles.
You're good, ma'am. You have no problem, none whatsoever at all. You're good. You don't have to change that address change in the labor certification at this point of time. When you go for the I-140, you change the address. It is going to create a zip problem for you.
Okay, sounds good. Thank you so much. Thank you for your time. Yep.
Thank you, ma'am. Thank you so much for calling. All the very best. Thank you.
Thank you.
Rahul Garu, before we take our next caller, I have a question. This is from Kotagiri Surender. Says, what are the chances of passing this border bill?
I'm just checking the comments from it. I would say about 60% probability that's part of it, though. There might be some tweaks and changes, though, because they need this bill. Why the Democrats need this bill for the funding of the Ukraine war. The Republicans need it to control the border. And this is a bipartisan bill where Democrats and senators both were involved in it. So there is a very, I would say, I would give about 60% chance for this bill to pass.
So it's a win-win for everybody.
Yes, it's necessary for both the people.
Got it. Okay. All right. Let's take our next
Because
call.
otherwise what will happen is that if Biden goes to elections without Ukraine, I mean, that's And Ukraine is in a desperate need. Even Republicans want some help to Ukraine. But Biden will be the person who is going to get, he will be the person who will be damaged in the elections, though. The other problem is that, of course, we know that Biden is a little bit lenient in the border. So if for the Republicans, border control and asylum control is an absolute needed. So that's, and this is already compromised between this, both parties at this point of time. And already that means that most likely be already been okayed by Biden. So hopefully so it should. But one I have to tell you is that one problem is right now, this is going to be in the House. Challenge will be in the House, not in the Senate. That's what my colleagues are telling me right now.
Okay, interesting. Okay. All right. Sir, I just have one other question. It says, how much is the H-1B fee increase from April 1st onwards? Are we expecting any increase in the fee for
there is some small increase on the H-1B fees itself, but unfortunately there is an other increase that this is a bad thing. This is a very, very bad thing. Every H-1B has to pay $600 for stupid political asylum, which our guys are not going to file. Our nice guys are not going to be eligible. Why? Because to cover the expenditure of political asylum, we have to pay $600 for each H-1B application that we're going to file, transfer, amendment, extensions, everything. Now, there is a little bit increase in the filing fees, which is to cover the cost for them based on the, increased inflation and other things from the past 5-6 years, which is fine. But the $600 is the worst thing that can happen to us. Every H-1B has to file. Amendment, extensions, concurrent filing, everybody has to give $600.
Wow.
Not good for us.
Right. But I guess also if the other way to look at it is it's an investment in your future. So,
What investment we are speaking about? We are giving $600 to the people who are good for nothing coming into this country.
Oh, that part apart, I'm saying if it's $600, then I don't think our folks who are, making at least 6-digit figures should have a problem though,
Well, no, still I don't want to give $600 to like
Sir,
that.
is there anything being done in order to sort of squash that or quash that?
We're working. We had a couple of meetings in our office. We're going to have a litigation team meet probably this week to discuss if we can, because it's going through the regulatory process though. So it's going to be, it has gone through all the process and procedures to increase the fees. So it's going to be very tough, but $600 for political asylum? Come on. What is we have to do? H-1Bs have to be political asylum. We understand, okay, they want to increase the scrutiny, they want to do prevent the fraud. No, they're just giving that $600 on how many H-1Bs we filed? So it's 85,000 H-1Bs in the lottery, 85,000 into 600. Come, buddy, tell me the calculation. That's approximately around 100.
It's not fair, and
plus 150,000 extensions, transfers, and all. We were speaking of 250 to 300,000 H-1Bs multiplied by 600. Now these people are going to be sitting in 5-star hotels eating our money.
Yep. I mean, it sort of comes back to the whole border scenario also, right? Like, because a lot of those people are demanding political asylum. So this money is to fund,
those people, which is bad, yeah. In this particular situation, I'm a Republican. I mean, it's issue based. I'm like, yeah, I know. My wife will hate me for it, but a lot of people will hate me. But there are certain provisions I oppose it.
It is the truth, right? So you can support one party or another. There's also something called right and wrong.
I'm an issue-based person, not like I will to support this party or that party. Yeah,
I agree. All right. On that note, let's go to our next caller. Caller with number ending in 0427. We're ready for you now. Hello.
Hi, sir. Thanks for taking time to answer our questions. So here is my scenario. My PERM got denied, and my company and the attorney already filed the reconsideration. And I got another offer from a different company, and they are ready to file my PERM directly. since they have a existing PWD and recruiting already done. So if I file with them, is it better to join their company and continue my employment with them until I get I-140? Or do you suggest having a concurrent H1 and working for both companies so that if I get my approval for my reconsideration request, I can retain my priority date and continue in the current company?
Very tough questions. So, but interesting questions though. Definitely, when you go join the company B right now, because your labor has been pending for more than 1 year, including the motion to reopen time, you will get 1 year H1B from company B. My problem will be that after that 1 year is over, and let's say, for example, company B files a labor certification within 3 months from the time you join, and the company A withdraws the perm labor because you left the company, or we get a motion to reopen denied. Now, at that point of time, how would you file the H1B extension after your 1 year H1B? You will have to move on to the F1 or B2 or H4 and come back to the H1B, which may be. So the rightful action for you would be that let company B file the perm application. Then they file the H1B based on company A's perm labor certification. Because let's say in the month of March, they file the perm labor for you. You join the company in May of 2024. So you will get a H1B from May of 2024 to May of 2025. In March of 2025, because your perm would be pending for more than 1 year, you would be able to extend the H1B until 2026 May, is that right? So you'll get 1 year extension. 2026 March, most probably March. March or May will be 26. Now, if you join the company in March, they file the labor certification in May, you won't be able to do it. You will have to get out of the H1B and come back, which is not a good option. Have them file the perm and then you can go and join. Because the likelihood for the motion to reopen or appeal with the ball card to come back in your favor without looking into the denial and all those things are very unlikely. So I would rather take a chance with company B rather than remain with company A. But on one condition, let them file the perm, and as soon as they file the perm, you can join the company. Okay?
Okay. Yes. And my max out date is April 2025. So if they file it, if they file my perm before that date, I'll be able to get that 1 year extension. Right,
your max out date is what?
My current H1B max out date is April 1st, 2025.
Oh, okay. Well, if that's okay. That's
so,
I thought that you already I thought that you already coming near the okay. So if your max out date is 2025 April though, you with the company B you can file until April of 2026 right now. How can you do that? The way you can do it with company B is based on the perm labor certification pending with company A, you could extend the H1B 1 more year extra. Do you get the point?
Oh, yeah, I got it.
So you're in much better shape than what I told you before. So if you move to company B, make sure that you get a H1B, you request the H1B until April of 2026 based on the perm and motion to reopen pending with company A. You would be eligible for 1 year extra beyond April 1st of 2025. Okay? We'll go to the next call, Randy.
Okay. So, like, can something happen, like if company A, like, withdraws it or something, like, can I use the, like, previous perm in the company B, like, there won't be any issues with using it?
No, like once you use one time, by the time you go to the second, by the time you go to April 2026, you will have a perm filed by company B to use it. You don't, first time you can use it. Second time you cannot use it because it will be withdrawn. You see my point? first time,
got it, sir.
it will not be withdrawn. You can use it. But in April of 2026, this company will withdraw it. At least I will assume it will withdraw it. So you will rely on company B's perm label to extend it beyond 2026. We'll go to the next caller, Nitya Garu.
So, thank you, sir.
Thank you, sir.
Thank
Thank
you
you so much for calling in. Yeah. Okay. Let's take our next caller. Okay, caller with number ending in 9556. 9556, we're ready for you now. Please press *6 to unmute your line, Andy. Caller with number ending in 9556. Hello? *6 to unmute your line. Okay, let's try this caller in a bit. Hello. Yeah, okay. Hello, sir?
Namaste,
Hello, sir. Can you hear us, sir?
Yeah, go ahead, sir.
Yeah.
Go ahead, sir.
Namaste and Bonran. Yeah.
Yeah, no.
Yeah, my
చెప్పండి,
question.
sir.
Yeah.
Yeah.
My question. నేను L1 వీసా మీద ఉన్నానండి. L1A వీసా. ఇప్పుడు ఏంటంటే నాకు ప్రీవియస్ I-140 అప్రూవల్ ఉందండి. H1Bలో మనం H1B I-140 అప్రూవల్ యూజ్ చేసుకుని మన EB1 లో ఫైల్ చేసుకోవచ్చండి. ప్రాసెస్ ఏంటో తెలుసుకోవాలన్నట్టు చేశానండి.
అంటే మీరు ఆ డేట్ ను EB1Aకు పోర్ట్ చేయొచ్చా అని అడుగుతున్నారు, అంతే కదా?
అవును, కరెక్ట్ అండి.
Absolutely you can. Absolutely you can. You were on H1B before, you got an I-140 from that H1B, you have a priority date established, and now you are an L1A visa, the company is filing an EB1A application, EB1C application, you absolutely can put the date from EB2 or EB3 to EB1C, no problem, none whatsoever at all.
ఓకే, ఏంటంటే మామూలుగా ప్రాసెస్ ఎలాగంటే నెక్స్ట్ స్టెప్స్ ఎలా ఉంటుందండి?
The company that you're working with L1A will file a EB1C application. And that EB1C application, they will also enclose the EB2 or EB3 I-140 approval that you got it. They will request that based on the section numbers, which I'm not quote and remember the section numbers. And you request them to port the date, they port the date. We do port the date every single day, no problem. You just have to mention that I have an I-140 approval. Please find enclosed I-140 approval and give me the priority date of 2018 when I got my EB2 or EB3 approved. That's it. And they will give 2018, okay? I'm just making the 2018 up. I don't know what your priority date is. Okay?
Okay. ఇప్పుడు I-485 తర్వాత ఫైనల్ స్టెప్ ఇదేనండి?
I-140, you can, I mean, if the priority date is current for you in EB1 though, you can file I-140, I-485, EAD, AP, everything together. Or you can file an I-140 in premium processing, wait for the I-140 to be approved, and then file the 485 right now. Okay?
Okay.
Thank you.
Thanks, sir.
All right. Thank you, sir. Thank you so much for calling.
Nitya Garu, it's a work for him to file the premium processing, because if he doesn't file the premium processing, he gets I-140 approval after April. Even if the priority date is correct, he will end up paying the EAD, AP fees for him, his wife, his children, everything. So I would rather pay that extra premium processing. Yeah, you're asking some question, Nitya Garu.
No, sir. That's fine. I was just looking at this question from US immigrant. Is 8 years criteria for I-140 or for H-4?
This is for the age out kids, preventing the kids to age out. Is the 8 years has to be I-140? No, they have to spend 8 years on H-4 based on my quick reading of the 370 pages bill, at least 4 years in H-4 before turning 21.
Okay, got it.
Not the I-140 must, the kid doesn't have to be 8 years on the I-140. I mean, after the I-140 is approved, it's H-4, total H-4 period spent.
H-4 period. Okay, got
it.
Okay. All right. Thank you, sir. Let's take our next caller. All right, guys. Caller with number ending in 2257. 2257. We're ready for you now. Hello?
Yes, I'm ready.
Hi, sir. Thank you for calling. Go ahead with your question, sir.
Yeah. Hi, Rahul, and thanks for taking the call. I have a question. My daughter has applied for changing her status from H4 to F1, change of status. And it's been almost 4 months. So they say USCIS processing, it will take 4.5 months or something. So I think we should get any time, we should get a decision. I'm pretty close. And she got an internship in summer, which is about to start in end of May. I still have 4 months. So should I start in premium now, or should I wait?
Yes, convert into premium, sir. Convert into premium, sir.
Okay, so it's better to convert into premium now, even if I'm pretty close to.
That's right. That's right. Sir. That's better. Yeah, yeah. She will make that money in the internship, and it's good for the internship to have it. Yeah.
Right. Another thing is, like, once approved, I know that we probably need to CPT from the college. So once she get a CPT, does she need to apply SSN or EAD or anything, or just she can work on CPT?
She can apply for SSN. And while the SSN is pending, though, while the SSN is pending, she can start working. She can show the receipt notice that she applied for SSN. She can start working. Okay?
Okay. So she can still work. Okay. And the last one, I heard about this border bill. I think it's good. She's been on H4 for last 12 years. So I hope that if it passes, then it should be good for her. And she's aging out next year in April 21.
And by the time, most probably your prior date won't be current. Yeah, she would be a perfect candidate for that age out.
Okay, and usually, just in case, if this bill gets passed, do you think how long it takes? I mean, just in roughly, like usually these bills get like 6 months, 1 year to get passed.
This bill is an emergency, national security, whatever. It is immediately implemented, though, because there's a lot of emergency provisions. Ukraine war is going on. The Russia is right at the border. They need the money. They need the guns, whatever they need. So but it needs to be done.
I don't understand bills, but it doesn't these are the different matters than the Ukraine war, but this includes this thing, so that everything
right. I know what you're telling. I know what you're telling. What is the Ukraine war has to do with my daughter and all those things? Yes, the immigration provisions sometimes will be just added to that big 370 pages bill. Okay.
Yeah, so it's good for us. Yeah, thank you. I'm really happy to hear
like a sleight of hand, I guess. Just trying to slip something in.
Thank you so much.
Rather than actually addressing.
Thank you so much.
We have some active live chat viewers who prefer to give you the $600 than to go with the $600.
I know, but if I cannot solve the problem, then they'll be not garka, not gatka. They lose the money with me and they lose the money with you.
Come on, Rahul, you can do this.
I have to have the reasonable certainty of winning it. If I don't have a reasonable certainty, they lose the $600 with me, and then they have to pay it there. They'll be na garka, na gatka. That'll be the worst thing.
All right.
So Nitya Garu, why this gentleman asked a very nice question. Why is this Ukraine and this border bill has to do with my daughter? So what happens is that even though it's a border bill mostly concerned about political asylum, controlling the border, Ukraine war, and those things though. So what happens when the senators sit down, some of the senators will put, I want this one, I want this one, I want this one.
Right.
Because they need to get the 60 votes, right? They want this, they want that. So that's where it becomes a patch of all those things. In Telugu language, pakka Telugu language, then atukula bonta antarantu itvanti billu.
And I don't think it's a theory, but what you're saying kind of makes sense, because everybody wants to get their piece of the pie.
Their piece of thing in there, so possible.
Okay, if you want me to do this, then this has to be this one. But I guess, if you look at the bigger scheme of things, at least someone's looking out for people like us, the immigrants who are employment based over here, and they're asking for these extra 18,000 green cards, which is great. Let's hope for more senators like that. All right. On that note, caller with number ending in 1221. 1221. We're ready for you now. Hello?
Yes, ma'am. Can you hear me?
Hi, ma'am. Yes, we can hear you, ma'am. Thank you for calling.
Hi.
Please go ahead with your question. Hi.
Hello, sir. Hi. Actually, I have two questions, sir. My husband's green card priority date is on July 12th of 2012. Right now, his perm is pending. It was applied on January 25th of 2023. So can we expect his green card this year?
Wait, he hasn't even filed the 485 yet, is that right?
No, not yet.
And what is the priority
His
date you
perm
said?
is pending right now.
What is the priority date you said? January?
July 12th of 2012.
July 12th of 2012. Okay. Its filing dates are current in EB3, July 12th. So it's not in final action date. I'm sorry, but I have to use some Telugu word for you. It's called Alu Ledu Sulu Ledu Koduku Peru. Alu Ledu Sulu Ledu Koduku Peru Somalingam. So what happens? There is a match that comes out, and there's a guy who comes to see the girl, and the girl gives a tea. The girl is supposed to give the tea to the guys, right? Now how the traditions are. And the girl and the mom are arguing that once I get married, what would be the son's name once the son is born? And the mom and daughters are arguing about, what's the son's name is. So that's the reason, Alu Ledu, Sulu Ledu, Koduku Peru Somalingam. So right now, you are very far. Because first, your final action date is not current. Your filing date is current, luckily, in EB3, okay? So the perm is not even
EB3 filed.
You haven't even filed the 485 application yet. Yeah, of course, you'll file in EB3. So you haven't even filed the 485 application there. So it's a bit far. And the other thing is that the priority date was been current for a long period of time for you from October of 2020. That's more than 3 years.
Right.
And I don't know what you're doing all these days. And now you want the green card by the end of this year, which has only 11 months left. Let's get step one, get the perm approved. Okay, file the I-140 in premium processing and 485, and then we'll discuss, okay? Okay.
Right, sir. And why? Because Nadi, nenu online master's degree chestunanu. It will be done by March 11th. So if I wanted to file for any H1 lottery, am I eligible for this year?
You are eligible for this year since you are completing the master's degree this year. You are eligible for H1B lottery. But you must have already have the H-4 EADs, right?
Yeah, ఇప్పుడు H-4 EAD ఉంది. ఇప్పుడు ఒకవేళ కనుక నేను
you can apply for the lottery. You can apply for the lottery. What I would do is that you apply for the lottery because your husband hasn't taken care of his green card from 2020 to right now. He's still filing, his perm is still pending. It's been for 4 years now, or 3.5 years now. So yeah, I would still be prepared to file that. Whatever happened, whatever it was transitioning the jobs and all those things, we know what happened. He didn't have an I-140 with this company, and then it took 4 years, 3 years to get to this level. So right now, baby step one, okay? If you get an opportunity to file the H-1B in the lottery, go ahead and file it. You first get the labor approval, file the I-140 in premium processing, and file the adjustment of status, and then discuss, okay? Don't go too far. Don't count the babies right now. Just get to step one, okay? Then step two, then step three. Don't argue about step 10 right now. That's the reason I said, listen to this one. Alu ledu, sulu ledu, koduku peru somalingam. Okay, that's exactly where you're fighting right now. Get the alu and then sulu. Okay, get married first and get pregnant. Then we'll discuss about the baby. Okay.
Okay. Yeah. Thanks.
Thank you, ma'am. Thank you so much for calling.
Thank you. Bye.
Bye.
Yeah, this is a perfect. There's not even a marriage. She's not even a pregnant now. Why to argue about the child's name right now?
Well, they seem to want to get ahead of the curve, sir. All right, let's take our next caller. Okay, caller with number ending in 9871. 9871, we're ready for you now. Hello? Hello? Caller with number ending in 9871. Please press star 6 and 8 to unmute your line. Star 6. Hello?
Can you hear me? Hi.
Yes, sir. We can hear you, sir. Hi, sir.
Hello.
Thank you for waiting. Go ahead with your question.
Hi. Thanks for the opportunity. So I have a quick question in regards to the visa stamping. So basically, I am looking for visa stamping in India for Dropbox. So, but I got my I-797 copy with my employer, but my spouse's I-797 is still pending. So can I go for visa stamping only with my I-797?
Wait, when you say you both are going for stamping, or
Yes.
only one person is going for stamping? Both are going for stamping.
Both are going for Dropbox.
Both are going. One is for H1, one is for H4, is right?
That is correct, yeah.
The H1 is already approved, is right?
H1 is approved, but the H4 is still pending.
H4 is not.
Both are filed in premium processing.
You do not need the H4 approval to go for stamping. You do not need it. You only need H1B approval. Even though H4 is pending, they can go for H4 stamping. Absolutely not needed for the I-797 approval. Okay?
Okay, awesome. And another question. So basically, like I got my I-140 approved from employer A, so but I have to switch my job to employer B. But so after I transferred to the new employer, so I filed my premium processing for H1 transfer, H4 and H4 EAD. So basically, like so in the premium processing, does it take longer than 4 months to get the H4
no, sir,
or
for
H4
the
EAD?
H4, if you have the H4 and H4 EAD filed together, if the H4 and EAD is not approved, send an email to us, okay? Send an email to Stephen at RN Law Group, or you can send an email to you. We'll take care of it. It's easy. Of course, there'll be a charge, and we can take care of it. Within 1 week and 10 days, you'll get the H4 plus EAD approved, okay?
Awesome. Sounds good. Thank you very much.
Yeah. Anytime when all H1, H4 and EAD file together, you only get the H1B approval. Send an email to info@rnlawgroup.com. We'll take care of it.
So what information I need to share for this email?
Just send an email. Send an email. My H1 is approved, H4 is not approved, filed together. If you can provide the receipt notices together, approval of the H1B that shows that it's been filed at the same time, not approved, then we will contact the USCIS. Of course, there will be a charge. We will tell you, okay? Okay then.
Okay. Sounds good. Thank you very much. I appreciate it.
Thank you, sir. Thank you so much for calling. Rahul Garu, there's one quick question from Jitesh Sridharande. Says he traveled to India mid last year and re-entered back within 3 weeks. Says my I-94 details are updated in the online portal, but unfortunately my entry-exit details are missing. What are my options?
What does mean entry exit though? So you mean to say on the I-94, the second page of the I-94 entry. But as far as the I-94, in the I-94 page, it says he's entered on so-and-so date and is admitted until so-and-so date. He doesn't have to worry about the second page, if it's been accurate or not. He doesn't have to worry about it.
Okay, cool. Thank you, sir. All right, let's take our next caller. Next caller ended. Okay, caller with number ending in 9838. 9838, we're ready for you now. Hello? Caller with number ending in 9838. We're ready for you. Hello? All right, let's try one more caller. Let's try another caller ending. Okay, caller with number ending in 9506. 9506, we're ready for you now. Hello? Caller with number ending in 9506. Hello? Okay, let's try another one. And then
Can you hear me?
Caller with number ending in 9838.
Hello? Hi, Nitya Garu and Rahul Garu. Can you hear me?
Okay, I think both of you have come back on. All right, let me put one of you on mute. Caller number ending in 9506, please hold on for 1 second. I'm going to put you on mute and we'll put you back on again, Andy. Okay, caller, the number ending in 9838. We're ready for you now. Go ahead, please.
Yeah, hello, thank you for taking my call. Actually, so previously, I left my previous company in 2013, and they had my I-140, but because I left them, so they withdraw my I-140. They kept it active for 6 months before withdrawing it. Now, if I want to join back the same company, I know they can directly file my I-140 given the fact that they have a continuous ability to pay since the time I left them. But my question is, what if they don't have the ability to pay? Then from which step they will file my green card process?
They can file from the labor certificate. They have to file from the labor certification. The ability to pay from the 2013 all the way they have to show to 2024 or until you get an I-140 approval. But if they don't have it in between, when you join them, you have to get they have to show the ability to pay from the time they file the next labor certification to the time you get the I-140 approval. Okay? Now,
Okay,
however,
sir, but they don't have to file PWG. Sorry, go ahead.
Unfortunately, they have to. If the ability to pay is not there, they have to. But there are a lot of exceptions for the ability to pay, though. We have a very good lawyer. Now, in our laws, what is the difference between other law firms and us is that we have one lawyer work only in one thing. It's like, for example, we have a Ray and Vic, he's a partner in our office. He only works on I-140, and he's very good in the ability to pay. The reason is that a lot of people miscalculate the ability to pay. For example, if you are supposed to pay $100,000, and you're not on the rules of the company, payrolls of the company, that means that they have to show the profits of $100,000 every year. Now, what happens is that sometimes if the prevailing wage is $100,000, though, if they're paying $200,000 for that guy, we consider that as a profit. You see the point? So that needs to be approached very liberally, though, to interpret, to show the ability to pay. So if they need anything, they can always consult Ryan Vick from our office, is the best guy in the United States, I would say, about ability to pay. Okay? Because otherwise, you will have to start the prevailing wage, which is going to take 8 months, plus approximately 4 months of recruitment time, then filing the labor certification. That's approximately about 13 to 14 months. The overall period will be more than 2 years for you to get to a level of I-140. While if the ability to pay is accurate, though, you can get to the I-140 stage just right now, immediately. Okay?
Okay, sir. Thank you so much. I have one more question if you have a time.
Go ahead.
Sir, in case so H-1B holder, which is my spouse, if he's a primary H-1B holder and if he works for company A, and his spouse, that is me, who has a LLC company.
You're an H-4 EAD, I'm assuming?
Yes, sir.
Okay,
so can my company, which is LLC, where my spouse is not a partner, can I work with his company together to get a project? Like if I get a project and I send to his company, like can I act as a mid-vendor for his company regarding a project?
Absolutely. You can do anything you want to. You're an H-4 EAD. Once the company has been formed, the company acts by itself, though. Can the company do this? Can the company do this? There is nothing involved. You are just a CEO of the company, okay? So the company can do any legal thing, absolutely. Can they sell marijuana? No. Marijuana, no. But can they do other things? Absolutely, yeah. Can they stock trades? Can they buy houses?
My only concern is,
Mm-hmm.
I'm sorry, my only concern is like when you go for stamping and then they see the, client letters and the vendor letters, and then they see that,
what you're practically telling is that you will be the middle vendor for your own husband's H-1B.
Yes, sir.
I would avoid it, though. It's not illegal. It's definitely not illegal. Like you say about the scrutiny that it's going to cause is not worth for you. Okay?
Okay.
Okay, thank you. It's not illegal. I'm not telling it's illegal. It's just, you have to then hire us to explain the things and all those things, which if I were you, I would not. Okay, thank you.
If you're not going for a stamping, I think you're not facing anything in that case. Do you think it is?
Yeah.
It is still okay?
Yeah. If you're not going for stamping, you're fine. I don't see a problem. Okay.
All right. I appreciate it. Thank you so much.
Ma'am, thank you so much for calling. All right. Okay, let's take our next caller. Ma'am, caller with number ending in 9506. We're ready for you now. Please press *6 to unmute your line. Caller with number ending in 9506. Hello? Caller with number ending in 9506. Please press *6 to unmute your line. Hello?
Hello, Rahul sir and Nicha ma'am.
Hi sir. Namaste Andy. Thank you for calling sir. Chappan sir. Please go ahead.
Yeah. I have two questions I will quickly squeeze in. And my first question is, I belong to the priority date of 2014 July, ma'am, Rahul sir. And I was AOS interview done in last year, 2023, January 4th. So after my interview, like accidentally, I pulled a copy of FOIA of my 485 to understand, whether or not the miracles were attached. So I came to know that the USCIS officer marked on the top USCIS section that there is a column, right? Are you a legal permanent resident? He said yes, and he checked the checkbox, and he put a date of that interview date, 1/4/2023. So do you think like I can, go ask them? Because I know that by the time the dates were already retrogressed.
But you did not get the green card yet, is that right?
I did not get the green card. So like I was taking an opinion just to see an advice, like if something, that we can.
No, you're good. You don't have to worry about it. Just a wrong click box there won't matter for you at all. You're good, okay?
Okay, so it's a wrongfully marked it. So I will not have any.
No, you'll not have any problem. Because you went through the interview. If there is anything, they would have corrected it, they would have created, they would have made you sign it. So they ignored it, you're good. You don't have any problem, okay?
Okay, I don't have any problem. And even if I fight, I will not get a green card because the dates are not current yet.
How can you fight? No, you can't fight. Your dates are not current.
I'm sorry, I had a perception. Yeah, no, I had a perception that,
just because somebody said you're a green card holder, you're not a green. Just because somebody said a green card holder, that doesn't mean you're a green card holder, okay? It has to go through all the things. Visa number has to be allocated. A lot of things are there, okay? Okay then.
Okay, all
right.
I got it.
Hope for
thank you, sir.
And I have, sir.
Thank you, ma'am. And I have this next question, sir. So my wife, actually, when we came back from India last September, so my wife's I-94 was given only for the date of, the passport expiry, not until the visa expires. So what are my options?
When is that I-94 expiring?
I-94 is expiring this June, and her visa is valid until 25, next year, October.
You have two options. You can, three options actually. You can extend the H-4 here in the United States with paying money to the filing fees to the immigration and probably to lawyers like me. Or you can have your wife, when you take a vacation, it will cost you the same to go to Cancun and come back, and they will give it. I am assuming that you already got the passport extension. Okay, those are two options. The third option is you already have the 485 EAD. You can just ignore it. Ignore the H-4.
Yeah, I mean, we don't have the APs, sir. APs are still pending.
That's fine. I mean, you have the 485 EAD, so you can ignore if you want to. If the AP is pending, you can still ignore it. I mean, you can if you want to, but it's up to you. I mean, travel is very important for you and you need it. Then, yeah, you probably have her go to Mexico and come back. She'll be fine, okay?
All right, sir. Thank you so much. And I have this last question for you. I'm sorry. And this is, my son is 17 years and he's going to the college. Yes.
Okay, good. Yeah.
Sir, it is my son is 17 and is going to the college next year, 2025. However, you know, because his EAD and AP are expiring too in next couple of months. So, do you advise him apply an F1 or just apply for the extension before the EAD AP expires?
First, apply for EAD and AP for sure. Okay, no questions in that.
Okay.
Now, then you need to choose, do you want him to continue, do you want him to use the EAD or not? It's up to your option. But applying, I think so, it should not be option for you. You should apply for extension. Okay?
Okay. All right. I got it.
Thank you.
Okay. Thank you, sir.
Right. Thank you so much.
Apply. Yeah, thank you. Yeah, thank you.
Okay.
Yeah, sure.
Sir?
Yeah. Thank you. Bye.
Okay, thank you for calling. Inkoka last question, sir.
Sure.
I'm just kidding. But to all our viewers, I know we have tons of people waiting in the Zoom call as well as the live chat, but unfortunately we're all out of time today. And unlike our last caller, this was our last caller for today. So we will see you same time, same place next week. Rahul Garu, thank you so much, Andy, for being on the show today and for bringing us this, you know, like this little ray of hope with this border bill. You know, that was really nice of you. So thank you, sir.
Thank you very much.
Right. And to all our viewers, bring back your questions. Call us same time, same place next week. And until then, have a great week. Bye.